Okay. Good morning and welcome to this public meeting of the Select Committee of Tynwald on Whistleblowing Policy Implementation. I'm Julie Edge, MHK, and I chair this committee. With me today are Tim Glover, MHK, and Corlett, MHK, along with our clerk. Please can we ensure that any mobile phones are on silent or switched off so that we do not have any interruptions. And for the purposes of Hansard, I'll be ensuring that only one person is speaking at a time. Thank you for attending this morning. And for the record, would you mind please introducing yourself and the capacity you're appearing before the committee today?
Yeah, my name is Abio Adeniran. I'm a former employee of Manx Care. I was a senior social worker and I was employed between 2015 to 2021 as an agency social worker, and then permanent as a social worker, and later a senior social worker.
Thank you. So just before we begin, I'd just like to explain how this hearing will proceed. Mr. Adeniran, can I check that you have received an email sent to you by the clerk of the committee on the 6th of March explaining our plans?
Yes, I have.
Okay. So we originally planned to hear from you in private on the basis that your written submission was primarily concerned with your own individual experience. If you have any evidence to give which does not make reference to your own individual circumstances, this can be done in public. So if you also wish to tell us about your own individual circumstances, then we can do that in private following the public evidence session. We have agreed to start on with that understanding and on that basis. So while we are sitting in public, we only wish to hear about any recommendations you have for the policy and governance of whistleblowing or any other matters of public policy. At this stage, you may not say anything about your own individual experience or about any other individual involved in your case. We can do that later in private if you wish. Are you content to go ahead on that basis?
Yes, I am.
Okay. Thank you. So with regards to whistleblowing legislation and following the previous Whistleblowing Select Committee policy, which was supposed to be rewritten to encourage reporting of concerns, make it clear and accessible to any individual and to remove duplication, would you say the revisions following that have been achieved?
I think it's difficult to achieve that when it can be separated, and it's separated in that for Manx Care there are whistleblowing procedures and a certain person identified to whistleblow to, and then to government separately there is individuals identified, and it's about the employee feeling comfortable that that information will be both it will be followed up, it will be investigated, and the person actually whistleblowing will feel confident and safe.
Okay. So prior to actually doing a whistleblowing case yourself, did you have any training from Manx, from your employer, or did you know where to access any training if it was online?
Yes, there was online training, but that I would say that came later on, and it was almost you had to fulfil this requirement while taking up our responsibilities. So if we had daily responsibilities and tasks and duty to do, that had to be our priority. If we're involved in child protection investigations, attending court, or for myself attending MAPA meetings, looking at the training online, it's finding that time to look at that training and digest that information and fully understand it.
Okay, thank you. Obviously, without getting into detail with your individual case, do you feel that there is a working culture where people are encouraged to whistleblow?
No, I don't think it's necessarily supported, and for example, it's not a personal experience, but there was a development day when I was not in work and I could not attend that development day, and then to put experiences forward. So that was only in 2025, later on in 2025. So people were asked to give their experiences, but nobody felt comfortable being able to give their experiences. So for me, what sort of use with public speakers and people not being able to feel confident and secure to give their experiences for fear of detrimental treatment?
Okay, thank you.
Good morning. Without going into the detail of your individual case, can you tell us how the whistleblowing policy could be improved in your view?
Well, I think it does need to be separated out, and when you think about the designated officers, and if there's an assistant director and a director, they should be fully aware of the procedures. If an employee escalates concerns or safeguarding issues that aren't being followed by departments, then you would expect an assistant director or a director to signpost or to show you that procedure and how that should be followed.
That's not really a comment on the policy, if I may say.
Sorry.
The question was about the policy rather than about the actions of individuals.
So just to come in there, you said that obviously there's a whistleblowing officer. So what you described there is that if you go to the whistleblowing officer, there's no way of escalation. It's purely to the whistleblowing officer.
No.
Is that correct? Yep. Okay.
Without, again, going into detail of your individual case, what role do you think non-disclosure agreement should play in relation to whistleblowing?
Sorry, pardon, can you repeat that?
Yeah, without going into your case again, what role do you think non-disclosure agreement should play in relation to whistleblowing?
It's obviously important that a non-disclosure agreement is there, but why should it be? If somebody needs to raise a concern, a legitimate concern, and somebody may be at risk, or why would that non-disclosure agreement be important when we are duty bound to divulge that? I'm duty bound as a social worker to divulge that to Social Work England. So we are duty bound to also divulge that to government or to senior management or to an assistant director or a director.
Mrs. Quayle.
Thank you. Good morning. Without getting into the detail of your individual case, can you tell us whether you think public bodies in the Isle of Man have the capability to deal with the sorts of concerns which can be raised by whistleblowers?
I don't think currently they have that capability. I think there is still work to be done, and that's to enable people to feel confident, and for those who are actually in those public positions, to allow people to discuss them. It should be an open agenda that enables people to come forward and being able to discuss things in a safe environment.
Okay. Can I just go back? You talked about you're duty bound as a social worker to report to Social Work England. Currently, our legislation does not have Social Work England as a prescribed person. Are you aware, has anything been reported to Social Work England, and has there been anything, any actions taken with regards to reports to Social Work England and whistleblowing?
It's a difficult one because that would have to be discussed in private.
Okay. Okay, thank you.
Nope.
Anything else? Okay. Are you happy, therefore, then, that we go into private at this stage?
Yes.
Okay. Good morning and welcome to this public meeting of the Select Committee of Tynwald on Whistleblowing Policy Implementation. I'm Julie Edge, MHK, and I chair this committee. With me today are Anne Caller, MHK, and Tim Glover, MHK, along with our clerk. Please can we ensure that all mobile phones are on silent or switched off so that we do not have any interruptions. And for the purposes of Hansard, I'll be ensuring that only one person is speaking at any time. So, sorry, just hold for a second. Okay, sorry, I'll continue. So, thank you. And for the record, could you please both introduce yourselves and the capacity you're appearing in front of the committee today?
Good morning, I'm Louise Quayle. I'm the designated whistleblowing officer for the DHSC.
Morning, and I'm Tim O'Neill. I'm interim chief officer for the Department of Health and Social Care.
Thank you. Since, and I'm not sure whether you've both been in post for the DHSC this long, but since the Tynwald resolution in 2021 on the implementation of the policy, can you describe your experience of any changes that have occurred since that resolution and the whistleblowing policy and process?
Yes, thank you, Ms. Edge. So I've only been in post since June 2025, have experience of the previous policy in one case that I've been involved in, but since the new policy has come in November, we haven't had any cases, so we haven't had any, I personally haven't had any interaction with the new policy itself.
Okay.
Thank you for the question. Yes, I've been in post since June 2025 as well, and for about a year before that I was in Manx Care as one of the executives there. Had some experience of the whistleblowing policy in Manx Care and understood the policy very well and was involved in that. But no experience in my current role since June 2025.
Okay. So if you've had involvement with the policy, do you think currently the way it operates, that you've obviously got experience of the previous one and the current one, do you think there has been changes that are beneficial to the process and to the individual and the understanding of managers when they're dealing with whistleblowing?
I'll go first, and then you. Yeah. So I've been on the island just less than 2 years. I can see the improvements that the new policy is trying to bring in, and I can see some progress. I think particularly around openness and accountability, but also around ensuring that the policy has a really wide understanding, not just from the general public, but also from all our staff, and of course multiple routes into the whistleblowing process, which is only a good thing. I think we need to be cognizant of not making it too complex for people. I think that's really important in my experience in other roles, and we need to be vigilant to make sure that the right cases go through the right policy route as well. But I'm certainly very supportive, in the corporate context of continuing to improve the process.
Yeah, and I think just to add to that, the kind of legislative changes within the new policy are really helpful. I think in terms of the prescribed persons as well, and so allowing people to report in whistleblowing to the department in terms of a regulatory role, that's very helpful too, providing that avenue for people to do that, I think is really good. Also the training that's been brought in, the e-learn package, the newer version to reflect the new policy is really thorough, and staff have reported that it's easy to follow, it's understandable, and can understand that in practice as well. So I think those areas are really good.
Okay.
Chair, I'm selling the training very hard in the department. It's really important that we engage with that, and staff are continuing to learn in that space and understand what it can offer, and that will continue. No question about that.
Okay. Well, would you mind, Ms. Quayle, going through, if you received a whistleblowing today, what the procedure would be and where you would, how would you start that procedure and what you would do with it? Obviously, your experience now will be under the new policy, but if you've had experience under the old, how that process may have changed and made it better for people to understand.
Yeah, so I think initially having contact with the individual themselves to let them know that the only one I've dealt with was an anonymous one as well, so it can be quite difficult with somebody who wants to retain that anonymity to make sure that they keep that anonymity, but also to understand the level of concerns that they have, so that you've got enough information to go on to process. But my initial meeting would be with the individual themselves to understand the concerns in detail, and then I would explain to them around would look at which protected disclosure that was relevant to what they were raising, and then it's very much case dependent. So obviously within the policy there's an escalation process if we needed to follow that, but as I said, I haven't used the new policy in full yet, and I think with my previous experience trying to triangulate the information when it's come from an anonymous with somebody who wants to remain anonymous, we do the best that we can and take their concerns seriously and try and get enough information in order to proceed with investigating it full and determine whether it meets the protected disclosures. In that case, I did involve HR, some guidance, because there was this potential, and I think just generally speaking, not in the case that I have dealt with, but generally speaking, there's in terms of a grievance process as well, so it can be quite blurred sometimes, so it can bring issues that might be a management issue, so making sure that we're clear on what the whistleblowing protected disclosures are and the policy which applies against the HR potential grievance side of things.
Okay. Can I just ask Professor O'Neill the same question from your previous role? Obviously, within this role, you've got an officer. But
Yes, I think Louise touched on a number of the important points. Ensure you know what you're working with in terms of the different categories of disclosure. The one thing I would say, in addition to what Lou said, is if you're unsure about the policy, then do make sure you speak to somebody. I know there's a lot in the policy about AGs, which is important, but also if you've got colleagues who've worked in this space as well, then do get their guidance, as long as you're not sharing sensitive information, of course. If I'm the lead officer in that whistleblowing process, I want to make sure I understand what's happening with it and keep an eye on the progress of it. I'm very conscious that sometimes investigations can go on too long. That's something I'm concerned about, and we need to be vigilant of, excuse my language, in government. And the point of the whistleblowing policy is obviously to unearth wrongdoing, and clearly when that's taken place, then the correct action needs to happen, and it's my role as the lead officer to make sure that happens.
Just on that, do you think in the past there were areas of confusion as to whether it was a whistleblowing case, it was a grievance at work case, and do you think this new policy now makes it very clear what whistleblowing is, what the categories and groupings titles are, so that any grey area that there might have existed in the past should now be gone?
Yes, absolutely, and I think that's what I was alluding to there is just that there's much clear definitions within the new policy as well. There's a clear direction in terms of the process flow chart as well. It's much better laid out for us in terms of whistleblowing officers to follow that. And it's very situation and case dependent a lot of the time, obviously, but that clarity is helpful.
We've just been preparing for this committee to ensure that we're pressure testing internally within the department the extent to which people understand the policy and how they go about it if they wanted to disclose something. So I think there's also a feedback loop we should be establishing in departments to double check that people know how the policy works, they know where to go, and if there's any lack of clarity, we can help them through that. So, but certainly we're on that improvement journey, and you can see it's a clearer and better process than the one we had before.
Can I just ask as well, because obviously the DHSC is quite a small department in terms of numbers, do you have any oversight over what is happening with Manx Care in terms of the same policy of whistleblowing?
I'm glad you asked that, Mr. Glover. So no, at the moment we don't, and one of the things that I'm sure colleagues around the table will know since I've been in post we're doing is to look at areas where we should be closer to Manx Care than we currently are. Now this may well be one, and it's something that I want to open a conversation with Manx Care about as their commissioner. Obviously alongside the Minister. We have to tread carefully there, because if we get too involved in individual cases, then we start to blur the lines between arm's length organisation and Commissioner. But certainly from my point of view, having done the preparation for this committee, it seems to me there's a space to move into there. We do look at, for example, a number of incidents and data, which I know you've previously talked about in the committee with Manx Care employees. but they're only a very vague read across. I think we need to be a bit more precise about it. So we've been talking to our performance and quality team about that in preparation for this committee.
Thank you.
So just to follow up on that, obviously anybody that whistleblows on wrongdoing, which you've described, it's a protected public disclosure for the public. With regards to, again, your previous role, because you obviously will understand the Manx care and how that happened, do you think there's a risk because of the way a whistleblowing under the current policy is raised and then it gets completely internalised? Do you think there's any risk to Isle of Man government because it's internalised? And what we're trying to encourage is get people to speak up. You know, a comment that we've heard today is when you see wrongdoing, it's time to speak up. And that's what every employee wants to do, but they don't feel it's a safe environment.
So the question about independence, Chair, I think it's inevitably context dependent. I know there are potential risks with an independent approach, particularly around decoupling those staff who are going to be delivering the change long term with the process. Having said that, I'm sure there are circumstances where a more independent approach would make good sense, and I don't think we should be blind to that necessarily. I think the other side of that coin, which I'm sure other colleagues will talk about or have talked about, is we're an Isle of Man government with limited resources, so we need to make the best of what we've got. But certainly, we need to be vigilant in terms of how the process is working. And if we feel that continues to be a problem, then we need to look at other ways of delivering it.
Where would you go if you were yourself identified as part of a whistleblowing disclosure?
I was identified as
part of a whistleblowing disclosure. Where would you then go? Because really you have a conflict then, don't you, about appointing an investigation?
I'd speak to HR and AGs about that conflict and understand how we'd manage that. You'll know, colleagues, there are a range of potential conflicts in our current kind of operational and strategic roles. So I would reach out for senior guidance on how we approach that and make sure we've written that down to give me some protection.
And yourself, if you wanted to whistleblow on anything, you'd see any wrongdoing you see, and what would you do at that point?
I'd probably start with my Chief Executive Officer. I think would be the most sensible plan. Obviously, there are multiple routes, but I would want to do that in the first instance. And I feel very confident that we progress from there with my Chief Executive Officer.
Sorry. Okay. Now, I just want to ask you: does the current policy allow that clear definition of what's whistleblowing and what's not? What's a grievance process? Do you feel that that's very clear in the policy itself?
If I make a start, you want maybe want to?
Agree,
I think it's much clearer. And we were having a conversation an hour or so ago about this, and I think it's what I've said already. I think we should be vigilant and understand and have a 360 feedback loop to ensure whether people do understand. Mm-hmm. My view is people are in really busy jobs already, and they have very busy lives, so we need to make it as simple as possible for people. I think we're making progress, definitely, but certainly what I'll bring back into the corporate realm is let's make sure we've got 360 feedback and understand how well it's working, and that's the best way of testing it, I think.
How frequently is it that there's whistleblowing and a grievance in the same issue?
Maybe.
Yeah, I mean, I don't want to speak about obviously the case that I've only dealt with one case, but I think from speaking with others as well around the process in particular, I think it can be quite common, and what we're trying to encourage is to people, I'm very open, people can come to see me first if they've got a query about what it might or might not be. So having that initial early conversation to say, I've got these concerns, does it meet this criteria or does it meet that? We can have that confidential conversation first, and I can give some signposting and some direction, which might, the policy does help in that. It does definitely say what's in. In the previous policy, it wasn't as clear, so I think that's helpful. But it's those early conversations I think are the most important thing to help understand what the concern is and then signpost people in the right direction.
And how confident are you that staff understand what to do if they have a concern?
Yeah, I think it's a mixed bag, to be honest. I think some people, our training compliance is 78% on the mandatory training that's online. We have had an issue with the data, so we've done our own kind of numbers and we've reached 78% compliance. And I think it's a mixed bag. With people who've undertaken the training have fed back that it's easy to use, they understand the process. I think then if there's a kind of time lull when they come to want to potentially use the policy or initiate a conversation, they might not quite remember what was in there, and that's my role in terms of helping to support them through that. But yeah, I think it's mixed, and we've got plans to kind of do that feedback loop that Tim was talking about to check people's understanding.
Okay, so you are trying very hard to evaluate how the training, the impacts of the training are,
yeah,
and how people understand that.
I think it's easy to talk about open door culture. From my point of view, it's my responsibility to ensure that we deliver that. We're a very small team, as you know, and the team has had some tricky things to navigate over recent years. And from my point of view, that open door policy, owned and started by me and continued by me, is really important. And I expect that of all officers in the department. At least people know where to go and have that conversation.
And of course there's then the follow-up, isn't there? Because just watching the video once and understanding it isn't enough in future years, and there is a mandatory requirement for it to be refreshed.
Yep.
So how do you have oversight over that?
So the first thing is just to touch on the 78%, and the 22% will be in half-hour one-to-ones with me over the next 2 weeks, and I want to know why they've not done it. And I think, again, it's about that feedback loop. We want to make sure that rather than us having to remind people to do the training, they're going back to it regularly as part of their daily practice. Department of Health and Social Care is partly about learning. It's partly about being a learning organisation, and over time we want staff to understand that that's part of their day job, not something separate from it.
And that 22% won't be an enormous number in reality, will it? How many people is it in reality?
We were just talking, weren't we?
Yeah, it'll be about 12 people.
Yeah. So we've got the opportunity, being a small department, to sensitively, of course, work on that at an individual level, which is what we'll do.
Any oversight of Manx Care's statistics on their training?
So we see some of their training data through their IPR pack, a very detailed IPR pack. I've probably referenced what I said before. I think there's an opportunity through the governance review output for us to look at where we might want to get a bit closer and understand from a commissioning point of view what that training output is and what it's delivering for Manx Care residents.
Just for the benefit of listeners, could you just say what an IPR pack is?
Sorry, it's not like me. I'm normally the first to challenge people on acronyms. It's the Integrated Performance Report that Manx Care produce with their board pack, which are freely available online.
Could I just go back to the mandatory training? Is time allotted in somebody's work time to do that? Some evidence we've received before now is, suggesting that people don't have time in their ordinary working day to fit this in. So do you allow time specifically for mandatory training?
Yeah, I mean, the department's very busy, as you can imagine. It's a small team, as Tim said, and it is very busy and pressured. But yeah, managers are always supportive of making sure people do their mandatory training and trying to find that time. It's not easy, but especially prioritising training such as whistleblowing is really important as well. There's a lot of mandatory training for people to do. We encourage it through induction with new staff and give them a significant amount of time in their first few weeks to do that training. It equates to quite a number of hours, but they are allotted that. But it is difficult to fit it in.
And we've had face-to-face sessions in team meetings on a Friday, and I've been really clear with staff: take time out of what you're doing to do it. And obviously setting an example. So it took me about half an hour. So the argument that I haven't got time is reasonably thin, I would argue. That's not being disrespectful to staff. It's just let's be honest about it. You need to prioritise it and get it in your diary and get it done. And also we can have a conversation then about the implementation of the policy once people have done the training.
And what training do you get as people who are dealing with whistleblowing as opposed to raising whistleblowing?
So I have registered on the designated officer, whistleblowing officer training course, which I believe there aren't any dates for at the moment, so I haven't had any formal training yet, but I've only been in post since June. But I think I called that out in our written submission, was that we would like some more training for whistleblowing officers, not just around the process, but some scenario-based training I think would be really helpful. They can get quite complex matters, so I think that would be helpful to me.
That's a really good point. We had the disclosure in litigation training not that long ago, which was incredibly useful and powerful. And some of that was scenario-based, if I recall, and I completely agree with that. trying to bring people into a kind of what would be a real situation and talk people through how they would actually go about it, I think is really, really valuable. So I'd want to be involved in that too. Obviously done the training that's available, but I'm very open and keen to be involved in more, because this is a really, really critical issue for government.
Yes, and just obviously whistleblowing officers have to take leave. So is when you say there's a designated officer training, does that go beyond the designated officer from a department perspective, so that you've always got somebody who can cover it? Because whistleblowing can happen and occur at any point. Yeah.
Yes, it does. So a data protection officer who is a head of corporate services would also be involved in that training, so that we've got cover. But again, a small department it is. We haven't got that many people to allow, but then we wouldn't take leave at the same time, obviously. Yeah,
that's a really key point. We've got to know each other's diaries really well, so we don't take leave at the same time. And yeah, my position on my role is I'm always accessible. So if something critical happens where a senior member of staff needs advice, I'm very happy to take that.
So I was just going to ask, designated officer training is different, obviously, to the general whistleblowing training. Does that take place online, or is that a face-to-face training session?
It's a face-to-face training session. Yeah, that's what I've signed up for on the e-learn banning system.
Yeah.
Okay. Obviously, we have heard evidence from people, and if a whistleblower comes forward, it's a serious health and safety risk, safeguarding risk. How do you escalate that?
Well, I would escalate immediately to a chief officer in the DHSC, depending upon what it was. But if it was a serious concern that was raised and it required immediate attention, I would raise that immediately.
And is there a process then beyond that?
So we'd obviously follow the protocol.
A review.
Excuse me, Chair. Sorry. Yes, we would obviously follow the process. But as Lou says, if there's something urgent and immediate, then my role as a corporate leader in the organisation is to do something about that really quickly. So, what I wouldn't do is say, well, let's follow the process, and a week down the line suddenly realise we should have acted straight away. I'm not going to do that. We're a very tight team, I think it's fair to say. We spend an awful lot of time together, so I'm very confident that we'd be able to have that conversation very quickly. And that's not just Lou and the exec, but more widely across the group.
And how do you deal with conflicts within the department, with it being a small department, and obviously then possible investigations? Where would you go for advice on people for investigating?
Yeah, again, I think it depends what it is, the concern that we're dealing with, but HR for some advice, as well as AGs, as Tim mentioned before. And again, depending upon what it is, we've touched on, I think in terms of the opportunity to go to someone independent as well for that kind of separate view, depending upon what it is you're dealing with. I think the expertise generally lies in the department, but if there's conflicts within, we'd have to understand what they were and who else could potentially be brought into that conversation if there was an obvious conflict that would to be at the detriment to the investigation if there was one. So we'd have to iron all of that out as early as possible. So
you haven't actually got anything to go outside independently if it's, a regulatory thing. And I suppose that brings us on to the prescribed persons list. Obviously, we know who there is prescribed persons on that, but from a regulation point of view, the DHSC R&I covers a lot more than what's in that prescribed persons list. Do you think there could be any extension that would be beneficial to support that independence that you would have employees would have access to, but
with R&I in particular, Chair, are you referring to?
It's just with regards to all the services that the DHSC, ultimately the Minister's responsible for delegating to Manx Care, so then the Manx Care processes. Obviously this time round, prescribed persons, we did include the GMC and a couple of things, but obviously we have heard from social workers. Social Work England is not part of that. Do you think that would be a benefit from your past experience? Or?
I think certainly from the department's point of view, the general model that we've both taken since I've been in post is that we're reaching out more. So the BMA is a great example of where we want to reach out more and understand, get a three-dimensional view of what's happening across the island. That's not to say we're not trusting of Manx Care or other providers. That's not the point at all. The point is that good practice is to get a three-dimensional view from a regulatory point of view, and that's what we're absolutely doing.
Just there, you mentioned you'd get advice from OHR and you'd get advice from the AGs. How do we break down the impression. We've obviously spoken to a number of witnesses, a lot of it in private, but one theme that's arisen is that they feel that OHR and the AGs are both protective of government as opposed to protective of a whistleblower.
I wouldn't personally say that that's the case. I think when we can't deal with something, or we have an uncertainty that we can't manage ourselves and we need that specialist advice from HR, then we would ask for that. It's not my impression that they are protecting government and not the individual. I think that's our role, is to protect the individual as well. So even if that was the case, we would be mindful and make sure that we were protecting the individual in that case.
Yeah, I think that's right. In my situation, my role overrides any of that. So I've not experienced that at all. But if I did experience it, I would challenge it, because ultimately, my job is to ensure that public money is spent wisely, but also to ensure that staff are supported in their roles. It's more than just the face-to-face operational work. And I believe passionately that the work we do together is a psychological contract as well as a physical one. So my role is much more than that. And if I certainly saw that happening within government, I would challenge it.
So we have actually heard from the Unite union rep about psychological damage and how it's recognised in the workplace. I'm pleased to hear a chief officer does recognise that it's a possibility. However, we've also heard from the employing body, the PSC and OHR, etc. And it seems to be they wanted that evidenced. However, when you hear one of the unions with a large number of employees on the island saying that psychological damage is happening, how would you address that in your department? I'm also, with regards to, we're aware through evidence sessions, public evidence sessions, that the Attorney General has seconded a full-time legal advisor to Manx Care. Surely, as the Department of Health and Social Care responsible for Manx Care, you must have concerns about that. That there's a need for that. I know they're a large employer, however, we've got other departments with near enough the same amount of employees. Did that concern you if you were aware of that evidence session?
Couple of things, Chair. So certainly if it's evidence, that would concern me. I think the other thing is this is my 27th year in the sector. So as I'm sure you know, Chair, I'm fully cognizant of how difficult these jobs are, actually. And in addition to getting on well with each other, which is not always easy, the frontline job in many of our frontline roles is really tough. So for us not to be paying attention to that would be a dereliction of duty. We clearly are. We will pay attention to that. We do pay attention to it. One little example, the culture of care barometer. From my point of view, wherever we see evidence that we can improve the wider cultural milieu, but then underneath that, if there are individual relationships that aren't working, that are going to cause potentially psychological issues, then we need to deal with those up front. And again, come back to what I said before, that's not about me saying any of our providers are not doing a great job. It's just that we know that these are really tricky jobs, really difficult jobs. Not everyone will agree with everybody about the same things. And part of the reason people go into health and social care is because they're massively passionate about it. So I think we're probably a bit more open to that than other service areas. So I'm fully aware of it, and certainly I'd want to work with colleagues. If we identify that's a problem, we should work to try and alleviate that, and that includes building good relationships with our union colleagues as well. I've recently, as you'd expect, we have regular pay meetings, and I attend those with Manx Care to understand a bit more from our union colleagues, the not just around pay but the more general feeling in relation to that. But we can always do more. I'm new into role, and I think, as I referenced earlier, we're starting the work of repositioning the department to be closer, I think, to understanding what's happening on the front line than perhaps we have been before.
Again, obviously, we are hearing from groups of people. A word that keeps coming up is manipulation of process. So with regards to going to a whistleblowing process, and then there could be circumstances where it could be an employment issue running alongside, which Ms. Quayle touched on earlier. We've heard the word weaponised being utilised as well. To me, there's something in the process there that perhaps people are not understanding that you can be a whistleblower and there can be another issue going on at the same time. However, a lot of people that have provided some evidence to us are saying that they whistleblow and then this becomes the challenge. And in all of that, the service user and the protection of the public may be lost. You might not have come aware of it directly because it could be Manx Care, it could be the DHSC, but what do you think in amongst all of that could be improved? Because clearly it's not working at the present time. If people are feeling I whistleblow, the detriment is I go into an employment matter.
Yeah, I think it's really important to keep those separate. So I think the whistleblowing process, as Tim said, we don't want to prolong any delays to that. And the case that I dealt with, it was swift. We kept a process. It's really important, I think, when there is a concern raised, that we take it seriously and we follow through quickly, and we don't delay any process or any outcomes. I think the grievance or potential employment issue alongside that, it can have an impact, but I think we need to be quite strict with this and make sure that we follow up on the whistleblowing side with that process quickly and effectively, and not kind of get blurred by other things that might be going on, because employment issues do generally take longer to resolve, potentially, depending upon what it is. So that's my view.
Two additional points, Chair. One is it's our job to be vigilant about that potential difficulty and conflict. And I think the second is that, I think we all, certainly myself and Lou, I wear two hats. So I wear a hat in terms of understanding and making sure that staff are supported, absolutely. But also the other part of the hat is the wider corporate role. Now, my job is to make those two fit together and be in sync. It's not always easy, but that's ultimately what the job is. And I think the main thing is being vigilant about that and understanding that potential difficulty right at the outset. I think once you're 3-6 months down a process and you suddenly realise you've got that potential conflict or difficulty, it's going to make it doubly hard to find a good outcome for anyone concerned.
Okay. So the outcome of the big case on the Isle of Man and which was proven, and then the Dr. Rosalind Ranson case, and which did involve the DHSC. As you're both new in the role, have you reviewed that and reviewed what was recommended, and also KC Brunner's report and KC Wright's report? Have you reviewed that to ensure that the processes, obviously DHSC and Manx Care and policy direction is being followed? A lot that we've heard is the process doesn't get followed. People just want to do their jobs and they want the process to be followed. How, as the Department for Health and Social Care, will you be able to address that if, again, in this report it comes out that there may not have been any improvement in that?
Let's take that first. And then
in terms of the right review, we have got some actions in terms of recommendations from that which we're currently actively looking at, and we do need to look back over the history to make sure that we're well briefed in terms of where that came from, and make sure that any changes to that we implement quickly.
I read some of that material before I came into post and reread some of it before I came into this committee. I'm very cognizant and aware that that's part of the organisational memory here. But at the same time, it's about looking forward and making sure we do the right things, which hopefully, some of the things we've said today will give you some assurance we are doing and we will continue to do. Second thing is, never rest on your laurels. This is really difficult work. So, we take this very seriously, and I really welcome the committee because it helps us to double down on what can, for some employees, be the most important thing that will ever happen to them in the career.
The basis for this question, the clue is in the title of the department, Health and Social Care. So we are, in many cases, talking about, life and death situations potentially. How does whistleblowing and safeguarding interact with each other, and who has responsibilities to report safeguarding? I would have thought anyone and everyone.
Yeah, so just quickly on that, there is a fully resolved safeguarding process through our local safeguarding board, which I'm a part of. I think the distinction, and you're right to raise it because there could be potential confusion between the two, thinking about this before the committee, the distinction as I see it is if you see structural wrongdoing in a safeguarding environment, you may well use the whistleblowing policy for that. Whereas if it's about an individual, my recommendation would be use the existing safeguarding policy, whether it's about safeguarding a child or an adult. Now, that's a nuanced distinction possibly for people who are involved in the business. So back to what I said before, if we at the earliest possible time, if we can support people to understand that and to reiterate the differences between those two, we've got more chance of cases not falling through the net. But again, it's about being vigilant. You know, that's something I know the Safeguarding Board do, being vigilant about the processes and practices that are in place, as you say, for anyone to speak up and raise an issue around safeguarding of either a child or an adult.
With regards to the integrity line, which is completely open for use, have you had any reports come to you direct from the integrity line?
No, I haven't had any, not since I've been in post.
Okay. So, but you wouldn't get to see any that had come in from Manx Care who you're mandating to deliver a service?
Not necessarily, Chair, no.
You have something in?
We were talking with other people giving evidence about the mediation process. Could you just explain to us how that works?
The HR mediation process. So
at what point kind of would you recommend that?
In terms of whistleblowing or in terms
Yes.
of the grievance? In terms of, so I think if it was, again, if the person wanted to remain anonymous, that's not something that we could pursue, obviously. But if the person was open and was hoped to be identified, I think after we've established if it met the criteria in terms of protected disclosure and then did an early kind of assessment of things, if mediation was required, I would contact HR in the first instance for their support and try and explain the situation with the individual's consent that was the right route to go down.
Just quickly, I'm an advocate of mediation at the earliest point, obviously context dependent, as Louise said. I go back far enough in my career. I was an advocate of restorative justice and youth justice many years ago, and I've seen the positive impact of that. It's the same basic principle, and you know, for as long as I'm in this post, I will continue to argue that should be a model that we use at the earliest possible point.
How, in your department, which we've several times now referenced as being quite a small department overall, how is anonymity maintained in whistleblowing disclosures? Because I'd have thought with a small department it was far easier to identify someone even though they were reporting anonymously.
I mean, Lou will say more about this, but we have to be super careful and super vigilant about that in our department, and it's something we've talked about a lot in the 9 months or so we've been working together. Just want to say a word or two about how we do that in practice.
Yeah, so it can be done. It's not easy in a small department, but it absolutely can be done. There's things that you can put into place and use approaches to make sure that that person does remain anonymous. And I think that's really important to have that in the forefront of your mind. If that person is very strict on that, that's absolutely, we have to make sure that that is the case. Like I said at the start, it makes it more difficult to take things forward in terms of asking other people for information to help you try and triangulate some of that, but it can and should be done even in a small department.
It's also about emphasising the basics of public service. So just making sure and ensuring that staff are aware they have a responsibility. When you work in a very small town, I often describe it like it's like an extended family at Christmas sometimes. But actually people have a responsibility as a public servant to behave in a particular way. So even when it must be very tempting to, you know, talk about individuals, and that's something that we're very clear about. You know, you still have a duty as an individual to operate in a particular way. So we won't necessarily be able to eradicate all of that, but certainly that's the culture that I promote.
And also then, how do we get to the next level where there isn't a fear about whistleblowing? In fact, it's being championed. How do we get to that level? Because all of us in this room are here because we want to make the process better.
I'll say a couple of things. The first is about the more champions there are, the more chance it is it will become embedded. And I think I've seen that in other realms, other walks of life. I certainly will play my role in the corporate group, and then also, you know, I have some influence in other parts of our practice. You know, obviously with Manx Care in particular. I think it's going to be I'll come back to the 360 feedback. So the more we can evidence we're making progress, the more chance we can build people's confidence, I think, that actually this is something worth engaging with. And it is something that people can trust, because I think we're talking to some degree about trust, aren't we?
Yeah, because I mean, it's well evidenced a good employer will always encourage whistleblowing and wrongdoing to be pointed out and corrected.
Yeah, and as you say, good and great organisations, that's the most valuable information they'll ever get, isn't it, in terms of improvement? So I completely agree with that.
Yeah, and I think we're kind of waving the flag for psychological safety in work. You know, I've done quite a lot of work in Manx care on that as well before I joined the DHSC, and that really is the basis for trust, like you say, and people feeling safe to speak up in the first instance. The whistleblowing policy is there for a reason, and it should be used for the right purposes, and it should be used for a positive outcome. And the member of staff shouldn't feel that doing that will cause them any detriment. That's absolutely not what it's about. So I think creating that environment, it takes time, but it's really important to do.
It's creating a culture, isn't it, where at the moment when whistleblowing is reported, it's done in a fairly negative way, or somebody's had a bad experience going through it. Whereas we want to get to the stage where actually we report this was corrected because of somebody actually lifting the whistle on this and champion what their role is in that.
I think that's right, and I think it's about in government leaders, and my view is that certainly the ones I work with are be open to that, rather than seeing it as a challenge and a potential risk. See it as as we were saying before, the evidence and the data and the intelligence they get from those cases will help them improve the organisation more widely. So it's just making sure we champion that, I think.
Can I just then ask how individuals who've raised concerns are kept informed about actions taken or outcomes reached?
Yes, a regular contact with the individual who's raised concerns at each point, and in between. So if there's going to ever be a kind of delay to information being gathered or an outcome, just to regularly inform them and to check with them how they want to be kept informed as well, because especially in a small team, they might not want that kind of conversation in an office, because they might not want to be seen to be going into an office with the whistleblowing officer, for example. So they might want an email update, or so whatever communication approach they want is what I would follow, and make sure that they're regularly informed so they're not wondering what's going on with the situation.
And as a department, you feel that's really important to do that for any individual in the process?
Yeah, absolutely.
Can I are you the Deputy Chief Officer?
Yes.
So the policy is correct? Yeah. Okay, that's fine, thank you. Can I just go back to the comments that you made, Professor O'Neill, with regards to structural wrongdoing or individual safeguarding? Is it not all safeguarding and it's structural?
It is all safeguarding, but we have two sets of processes, and I suppose what I'm describing is one practical way of enabling people to take their concern through the right process. Ultimately, something's been identified that needs to be acted on, and as long as we make sure that happens and happens effectively, which process it goes through is probably less important. Having said that, if we can be super clear with anyone who wants to use those processes, the distinction between one and the other, that should help most people to navigate through them. And as I said before, I'm a bit long in the tooth when it comes to safeguarding, and I've been involved in lots of attempts to try and get communities to understand how to engage with safeguarding. As you know, it's a complex and difficult area, but the simpler we can make it for people, the better. And that's really what was behind my comments.
And does every employee have a duty to report safeguarding, whether it's in their internal policy area that it says to go to your line manager? If you go to your line manager and they then don't do that, have you had any experience of that at all?
I've not had any direct experience of that. To answer your first part of your question, no, absolutely. Everyone has the ability and should be encouraged, actually, to identify where there are safeguarding concerns, because that's the only way we can improve the safeguarding of everyone on the island.
And with regards to, there's quite a large of third-party organisations operate, not necessarily directly for the DHSC, some do, some for Manx Care. What's the reporting mechanism for individuals that are perhaps your service user using an external organisation to provide that service to you, What's the whistleblowing policy for them, process for them?
I don't know, I would have to check that out, Chair, I'm not sure.
My expectation would be that if we've commissioned a service as part of their the baseline of their commission would be that they would engage with those processes, and you've raised a really important question. Let's go back and check that. Very happy to do that. Certainly services that we're responsible for should be operating to those standards in the same way that we do. But you'll know also, Chair, I think we've been on a bit of a journey in terms of building the quality of our contracted work over time. And referencing again the governance review, one of the things that Tynwald members have said they wish to see is a move towards a clearer and more consistent commissioning approach, and that will help us to be much more effective in that space, so everybody works to the same standards, and that's something I would feel very comfortable to support.
So we have heard evidence from somebody who's worked in a service area environment, and I'm going to say particularly now it's actually an individual that is under the care of Manx Care, and then the possibility is there's a concern with the third party provider. Would you ever get to hear about that?
It would depend, Chair. So, I have a very good open relationship with the leadership group in Manx Care. There isn't, as far as I'm aware, a formal process to report those particular types of concerns. I would hope and expect that would happen. Certainly there are myriad occasions when, through one-to-one processes with the Chief Executive of Manx Care, for example, or through regular meeting cycles, that we do cover some of those issues. But I couldn't guarantee you that it would happen necessarily with one particular case.
So if you've contracted the service as DHSC but delegated it to Manx Care, there isn't that loop, 360 degree loop at the moment?
Not that I'm aware of, Chair, but
okay.
Hopefully what I've said is I recognise that that's something we need to do better, and the commissioning route will enable us to be much more close-sighted about that. As you rightly allude to, these services we're still responsible for them, and the policies and processes that support that should be in place.
And ultimately, the Minister's accountable for all of this, and I suppose that's where we're asking the questions. You delegate a function to Manx Care, and it's how it comes back up through, because if there is any serious situation, we all know who's accountable for it. So,
recognising that you're both new in your roles, the submission that the department put together to us, which we're grateful for, said that you don't routinely use non-disclosure agreements or settlements. Can you describe those circumstances where the use of an NDA would be appropriate, and an NDA doesn't anyway preclude the whistleblowing process? Do you want to take this one? I'm not quite sure I understand the question. Can I describe a situation where we would use a non-disclosure agreement? Well, I can't ask you where
Sorry,
you've used one, because you haven't.
No.
But can you think of a circumstance where one would be appropriate to use?
I mean, the narrative that's already written around this, I'm sure you already know, and so one example would be if there was going to be a great reputational risk to wider government, is one that's always used as an example. I have experience of them being used in organisations I've been involved in previous years, but that would be an example. If there was a significant risk to the wider government, that might be an example of where it might be used. But as I say, I can't describe any specifics on that.
But it wouldn't, an NDA, and we keep emphasising this, doesn't preclude talking about a whistleblowing episode.
Absolutely not.
I'm just interested in the terminology used there. If there's a risk to the wider government, if it's public safety, it's a risk to the public, possibly. So,
yeah, Chair, if I may, I mean we're talking about possibilities here, so I'm struggling a little bit, if I'm honest, to nail it to something specific. I'm trying to describe in general terms what I know to be the boundaries, but it's an individual case, and I have to kind of bring it back to that. It would be about me using my experience and skill, but also potentially taking the relevant guidance in an individual case. It wouldn't be about me. There's nothing generic about it, I don't think.
Yeah. Just with regards to, again, we've had quite a lot of evidence. There's been various reports mentioned during those evidence sessions, reports that have never been published, reports that have never actually been discussed with the individual that's brought that report into being. So for that report to be created and an investigation carried out, there's then reports done, some contradict each other. Who has oversight of reports that are done, that are investigations into whistleblowing situations?
So I would, if I was involved, would draft the report, the final, based on the investigation and all of the information, draft the final report, and then I would share that with the Chief Officer for oversight, and I would absolutely share that with the individual who has raised the concern.
And what about independent reports that part of the organisation may decide to go independently outside of the organisation? What happens with those independent reports?
Yeah. Two things, Chair. We're talking in theory rather than reality, unfortunately, but I get where you're coming from. Ultimately, what Louise said is absolutely right, is that the oversight of any kind of report like that would be mine. We're talking about a theoretical situation, but certainly from my point of view, that would be my expectation, depending on the nature of the report and the context it was written, of course.
Okay. And as Chief Officer, we're aware there are reports, so it's not theoretical. We are aware there are reports.
I just don't know which reports you're referring to, Chair, so I do
No,
apologise.
that's fine, no. But as Chief Officer, if there's concerns being raised in those reports, you would want to know, I'm quite sure, and you would take action if there was, you talk an awful lot about transparency, accountability, and if that came out of those reports and you're not seeing it, is that a loop that needs tightening up?
So I agree absolutely with what you're saying in terms of it depends. I'd need to see how the report was commissioned, if I'm honest, to be super confident with that. But my general point is absolutely I want to be made aware and see and understand where any kind of significant report like that has been written, where there are significant implications for the department or for an individual within them.
And the person that report is being done for, or the case, they're entitled to see that in full, aren't they, as well?
That's my understanding, but again, it's dependent upon the report and how it was commissioned.
Not redacted, but in full.
Right, yeah, that would be my expectation.
For openness and transparency, yeah.
I'm struggling a little bit, sorry, Mr. Glover, with the kind of theoretical nature of the conversation, but certainly what I've said throughout the discussion is that openness is at the centre of everything here. So absolutely, they're able to see those reports.
Can I just ask if you had any previous experience of that, where there's been whistleblowing and you've worked in the service area for a significant time. Have you got any experience where whistleblowers come forward, there's independent reports, investigations, serious case reviews, etc.?
I've had experience of that in my career, yes.
Yeah. So your experience is that the individual would see the full report, and should there be an appeals process, do you feel?
In previous roles, that's what would have happened, yeah.
Thank you.
Sorry, can I just try and sort of untangle some of this? I think if there is say for example, a bullying complaint, individual says I'm being bullied, let me put it another way.
Employment, isn't it?
Typically in an employment matter, if you are, for example, accused of misconduct and it's investigated, then you as the accused have the right to see everything and to know what's being said about you. But I think in a whistleblowing case, maybe that you're accusing somebody else of misconduct or of poor performance. And in that situation, I think what the committee's heard from other witnesses is that the whistleblower's job is done. If my whistleblow is that we, as a department, are risking the health of the public because of something somebody else is doing, which I don't agree with, maybe I'm not entitled to see the entire report. Is that not right?
I think it depends on what it is, to be honest, and the agreement with the whistleblower at the outset. So I think if the whistleblower, in terms of the outcome, I think it's important to share the outcome of that just to some degree. You might not be able to share all of the information with the person, but I think it's important to let them know what happened as a result. But, not necessarily with any personal information about other people. There may be some redactions required to that if it's necessary, but a version of something should be shared with the whistleblower. If they say, I don't, I'm sharing this with you and I don't want any other conversations about it and want to be anonymous over to you, I think that's different. But I think it's that agreement at the outset as to how we manage that investigation and what the outcome is and the expectations of them as a whistleblower and what we can deliver as an organisation as well, and agree that at some point.
The whistleblower deserves closure as much as knowing that if they've felt it was serious under the prescribed persons, that there was either action or not, and they need to have it explained why not, so that then again in the future when they're in their employment they know actually that's why that happens that particular way. But it's that closure element, I think, that we're hearing a lot of evidence that people don't get. So it's good to hear that you'd be quite open and transparent with that. Anything else? No?
Over time. So I'll just ask one more curveball question. If you were writing our report, if you were writing our report, is the one recommendation you would make to Tynwald?
My response to that, I'm sure Lou will have a view. I've talked a lot about 360 feedback and testing whether the whistleblowing policy is working. I think that's the most important. So let's commit to doing that, and ultimately the evidence that brings forward will enable us to understand how well the policy is working, both for individuals and for governments. That would be the one recommendation I'd make.
Can I just ask, because the new process is a report that goes into the middle, into OHR. We've heard from some witnesses from departments that they don't really know what happens then. As Chief Officer, do you know what happens with regards to those reports that go into the centre?
The report.
There's a monthly report, goes from departments apparently under the new policy, and goes into the centre, goes to PSC. Does it go to COG? Do you get to see?
So we COG sees some OHR information. Whether it's that particular information, I wouldn't be able to without going back to check. I'm not sure, Chair, to be honest.
Okay. And then obviously I just want to touch again on your past experience, a bit of it, and independence. Clearly on an island we deal with every element of health and social care. In the UK it might be the local authority deals with parts and that. With this being an island, and a lot of people know a lot of people in conflicts, do you think independence would be more helpful to perhaps not have some of the situations that have been presented?
But just to go back to what I said before, I think, again, context specific, there may be circumstances whereby an independent approach might work. That's just a kind of personal opinion, nothing more than that. I also understand, though, that there are some potential pitfalls there, one of which I've listed earlier, which is that if we decouple the people who are going to be delivering the improvement from the process, that creates a potential risk in terms of wider learning and improvement. But in principle, at least, there are certain circumstances, I think, where an independent eye can help us.
Okay. Anything else? Thank you. With that, we'll sit in private now. Thank you.
Stand.
Thank you. Good morning and welcome to this public meeting of the Select Committee of Tynwald on the Whistleblowing Policy Implementation. I'm Julie Edge and I chair this committee. With me today are Tim Glover, MHK, and Anne Corlett, MHK, and our clerk. Please can we ensure that any mobile phones are on silent or switched off so that we do not have any interruptions, and for the purposes of Hansard I'll be ensuring that only one person speaks at any time. So thank you for attending today. Would you mind both introducing yourselves and the purpose you're in front of the committee?
I am Lisa Kelly. I am the Department Designated Whistleblowing Officer for the Department of Education, Sport and Culture. Just to be upfront, I've been in post for about 8.5 months, and to date I've not yet had to deal with any whistleblowing cases.
Okay.
Thanks, Lisa. My name is Graham Kinrade. I am the Chief Officer of the Department of Education, Sport and Culture.
Thank you. So I'll have to come to the Chief Officer on this one then. So with regards to the previous committee investigations and the changes that were to be implemented then, and obviously there's been a new couple of versions of the policy since, how would you describe the implementation of that policy and how it's working?
The new version.
The new version even, yeah.
Look, I think in an organisation of this size, implementation of policy is always going to be a challenge, and purely because we have such a broad breadth of staff. They work in so many areas, and they have access to technology, or they don't have access to technology, and all of the pieces that go with that. But that's true of any policy that we implement. So we work very closely with the heads of each division, the heads of schools, wherever it may be, so that we can cascade information. And I think cascading is probably the best approach we have within a wide organisation to ensure that people are cited on the policies that need to be cited upon. Equally, any policy that we have, this one included, is available within a single area within the department's intranet, a platform that we utilise where all staff can access and see any policy they need to see. That probably answers, I think, at that point.
Okay.
I'm about to start talking too much.
How confident are you that all of your employees throughout the department, and obviously third sector that are contracted to the department, understand the whistleblowing policy and process?
I would like to sit here and say I'm 100%, but I'm not. The department faces a challenge within training, and that challenge is that we currently have 3 ways in which we're disseminating the whistleblowing policy training. We're using It's Learning is a platform that the department has been using for quite a long time now, that education staff tend to use. We equally have the government training platform for government staff, but then we also have some staff who don't have access to either of those platforms. So actually we have utilised a single URL that any member of staff is able to get hold of and access the training. The problem with that, there's a plus and a negative. The plus is, I think we've given as many channels as we can to enable people to access. The negative is, you can't report on the single URL bit. So I don't have any information on how many people have been able to take that up. There are plans to resolve this. Now, I don't want to be in 2 different platforms for training of staff. We need to consolidate into one, and that's a piece of work that's currently ongoing.
So you're currently not aware of how many people have completed whistleblowing training?
I could not put my hand on my heart and say no.
Okay, thank you.
Do you think this new policy has got rid of some of the greyness maybe around what is a whistleblowing case, what may be a work issue? Do you think this new policy is a lot clearer now in what whistleblowing is and what it isn't?
I think that's a very fair statement, and I think each iteration of the policy is bringing a little bit more clarity as it goes, which I suspect you would expect to see in a policy as it iterates. You'd expect to see improvement in there. But yes, I think that clarity is better in the October 25.
We mentioned obviously you haven't at the moment got clear oversight about the training and the uptake of it, but do you feel staff that maybe you've spoken to have a clear understanding now of what the policy is and isn't?
Yes, and I'm not about to suggest that my methodologies here are scientific, but as I travel around schools, and I've been in 2 or 3 this week, I tend to take the opportunity to ask staff, 1, if they're aware, and 2, what their view of the policy and the training is. And broadly what you get back is positivity, that it's clear, it's understandable, it brings the clarity that I think you referenced earlier, Mr. Glover. And my conversations with the staff that I've had would say they are aware of the training and they are completing it. but I can't evidence that in data. That is anecdotal as I speak to people.
Of course, the next stage to get to, because whistleblowing has had a lot of publicity, obviously, of late, and not all of that has been very positive. So the next stage is, do you feel now confident to bring a whistleblowing case?
I think it's important to understand something about, shall I make my words clear? There's something here about culture and the culture of an organisation. So the Department of Education, Sport and Culture, I've sat here a number of times and we've talked about the culture and the progress of this department. I know that I work in a department that has a very clear focus on safeguarding, a very clear focus on health and safety in some of its areas. As you're well aware, the 3 areas may have a slightly different focus. Safeguarding sits across all of them. Health and safety may be more important in others. And I think there is a real culture within this department of understanding that it's almost the duty of employees to raise concerns, to ask questions, to be professionally curious, not to shy away from the things that would bring improvement. And I would not sit here and say the culture of the department is perfect. I don't think you ever reach that in an organisation. You're constantly wanting to improve, forgive me. But I do think that we're well down a road of an organisation that recognises the responsibilities for the children, the young people, the public that we deliver services for each other, employee-wise, and the need to speak up if there are concerns to speak up. And I actually think that's our greatest protection, is to build and build and build and develop that culture so that this becomes quite an open, accepted process. Quite frankly, I welcome the challenge and I welcome the scrutiny and I welcome people feeling that they can say, this doesn't quite feel as it should.
You're obviously, employers are dealing with children.
Yes.
To a large degree in that part of the department's responsibilities. Where do you see, it's clear we've got a whistleblowing representative to go to with a whistleblowing concern, but quite often that whistleblowing concern may also be a safeguarding concern. So where do they go? Because everybody has a responsibility, would you agree, to report a safeguarding issue straight away?
100%. And I think, if we take whistleblowing aside for a moment, I think staff are well versed, and every school, every organisation, every division knows who its safeguarding officer is, what the reporting lines are, and how those things are raised and escalated. The department does annual training around safeguarding, and that's done face-to-face. It's not an online thing, so we have a much greater reach around our safeguarding training because it's so important. So absolutely, I think if people have a safeguarding concern, they recognise the line that they can take to enable them to raise that.
But the point I'm also making is that it could be both, couldn't they, at the same time?
Absolutely. It could be both, and I think one of the decisions a whistleblowing officer has to take is, what is it I'm faced with here? Is this purely a whistleblowing case? Is there something in here that I need to raise more widely? And often, if we take the integrity line as an example, if I see something coming through there that will be anonymous, but maybe speaking of a safeguarding, then that would be brought to myself as well to try and make a decision on what is it that we're looking at here and what is the most appropriate process that we can utilise to get the outcomes that are required by everybody.
So with regards to that report in the integrity line and your whistleblowing officer, do you have the complete delegated authority to be able to act on that whistleblowing and keep that anonymity to make that decision? Because that's how you've described it. So, yeah. And where would you go for advice outside of the department? Where do you go if you've got a whistleblowing report? You're not too sure. You don't go to anybody in the department. Where do you go? Can you go through that process for me as to what you do if you've received one? You're saying you haven't. I'm sorry. But you've received integrity line reports, have you, in the last...
We have, but not whilst Lisa's been.
Not whilst Lisa, okay.
I think OHR is a normal first point of contact as soon as the report has come in. We've got to log it with OHR. But if there was a concern over safeguarding, I'd have no issues going to our safeguarding officer, who just sits literally over the road from where I sit, and have them discussions. I think I obviously speak to Graham as well, and between us we would certainly agree the way forward and the best process to answer the concerns raised.
How do you anonymise that when you're having those conversations?
would be hypothetical.
If I may, everything that's come to the integrity line for us at this moment in time is anonymous. So it's anonymised, which can bring its own challenges. I mean, I recognise the power of that anonymity because you can build the culture as much as you want, as I was talking before, but sometimes people will find a comfort in being able to speak anonymously, utterly accept it and have no issues with it at all. It does bring its problems with feedback loops. I know there have been improvements through the Crime Stoppers to enable us to deliver that, but it does mean that we can be faced with difficulties of informing people if they don't want that feedback loop either. But equally, it's kept anonymous because it's anonymous.
It is anonymous, but away from the integrity line, whistleblowing policy, how would you do it? How would you keep that anonymity? Because you said you'll go to your chief officer or you'll go to your safeguarding officer.
I think it depends on the case as well, and it's probably difficult to talk about this hypothetically. I've not had to deal with one, and I haven't got an example in front of it I can bring to mind. But I think it would depend on the content of the claim.
It would, and well, I'm not going to speak about cases clearly. You know, sometimes they are reported directly to myself, and then I would take them to the officer, and sometimes they would go to the officer, and the officer would then have to find a way to have those conversations with me. If I was the point of escalation, but anonymity has to be protected. It's just a taken. It cannot be discussed, and there is no, but maybe in this instance it cannot be discussed. And if we don't keep that anonymity solid, then the system falls down.
Yeah. And I'm sorry, I know you haven't had any cases, so I am asking you hypothetically. However, have you had the training for an investigating whistleblowing officer?
I've had the investigation officer training, and I'm waiting for OHR. The latest date on it.
So you haven't had the designated whistleblowing training?
No, it's been unavailable at the moment.
Okay, so how would you deal with a situation to ensure there was no detriment to the employee after raising a whistleblowing with you? Have you not experienced it in any other roles? No.
No.
You've not done whistleblowing. Okay.
So I'm used to treating things with confidentiality and that side of things.
Okay.
Can I ask you, Chief Officer, if the whistleblowing case or issue raised directly affected your role, where do you go then?
So if a whistleblowing is raised about me, I don't think that would come to me for my opinion.
But where do you go with that? Because you have to obviously separate yourself then, don't you, from the process?
But I think it should be clear, I'm separated from the process anyway. Unless it happens to be reported to me, then I'm part of the process. But my immediate action would be to pass it into the process. I think it's highly unlikely somebody would send it direct to me. If it went to the whistleblowing officer.
I'm talking about the actual whistleblowing.
If it was about a senior officer.
If it was about you.
Then
how do you remove yourself from the process then?
I think the policy is clear on how I need to stay away from that.
I think there's other angles you can bring the whistleblowing in. There's 4 or 5 different paths into raise a whistleblowing, and there's other, I suppose, if you were part of the issue, there'd be other people who you would go to point OHR. It depends on what the subject was. You could certainly go to different areas for advice and guidance.
Okay, so if there was a whistleblowing complaint about a senior officer within the department, where would you expect that to go? As the Chief Executive Officer, would you get to know about it? Have you had any in your career at this stage, I suppose, is the question. Have you dealt with any?
No.
You haven't? Okay.
The main purpose of this committee is really to is the policy and process working, and can we improve it? So I'm going to have to go back to, training, because knowledge and understanding of the policy and process is fundamental. And that's why mandatory training is. So you said that it's difficult, that you needed to consolidate it, and that you had a plan. So what's the plan?
So the plan is education staff should be involved within the overall government training platform. There should be one training platform for government, and I'm aware that government is looking at that at this moment in time, and we are liaising with the appropriate people who are looking to develop that to ensure that all of our staff are included within that.
And have you got any sort of timescale on when that's likely to
I haven't off the top of my head, no. I could find it, but I haven't got it with me.
Okay. So, although you don't have the data now, when you get this plan in place and you can collect that data, what do you intend to do with it?
With the data?
With numbers. How are you going to evaluate the quality of the training, the impact of the training? How would you expect to do that when you have the data to tell you how many people have come through? Are you going to take feedback from those people who've been through the training to see how it's effective for them?
I think the only way, so numbers alone, let's imagine we end up with, I have a figure of 70% completion. That tells me nothing about quality or impact. Quality or impact can only be done through face-to-face conversations. And I wouldn't expect that I would be running around having those conversations, but for the leads of each areas, I would expect conversations to be had with staff to say, okay, you've completed. What's the opinion? Do you feel enabled? Do you feel capable of doing the things that you need to do? Was there some deficit within the training? The only way of gathering that, I personally believe, is in face-to-face discussion with the individual having completed the training.
Okay. So if that were to take place in those areas that you've suggested, does that feed back to the department?
Yes. It would do in this instance. So there are specific policies that we would seek. Safeguarding would be a classic one, to ensure that everybody has access to that safeguarding training, and it's important that I understand, so that's reported back up into a governance structure within the department.
And do you make an effort to find out why mandatory training hasn't taken place, or why individuals haven't taken the opportunity to do it?
I would ask the lead of that area to find that out, yes, and to bring it back.
Okay, thank you.
So the prescribed persons list for reporting whistleblowing actually only covers the Safeguarding Act for education. Do you think that should be extended to cover the Children and Young Persons Act or anything else? Is there anything in there? Or obviously in the UK, I think there's now a reporting body for teacher conduct, etc. Do you think, is there anything? We have heard evidence from people that have worked or are still working for the department that have whistleblown. So how do you, is there anything, I'm guessing you're not aware of these cases, but because you've said you're not aware of any. However, if the prescribed persons list was extended, do you think that would help the department? So to say it was extended to report into, what could I use as an example? The Children's and Young Persons Act is the responsibility mainly of the department, but report and conduct of teachers, which is outside of normal government routines. We don't have that on the island. Do you think there would be anything beneficial that would help people come forward? You say you've got no cases come forward in 8 months, which surprises me, but at the same time, is that because people are afraid to come forward? Is there a barrier there that's stopping people coming forward?
Okay, there's a few points there. When I say I'm not aware of, I am aware of whistleblowing cases that have been live in the department. I don't know who they are. They're anonymous. So I just need to be really clear on that. I'm not unaware of what's going on. I think the prescribed persons list is clear. I don't personally look at that and think, oh, we should really change that and move that here. I think so long as everybody is clear on where they need to go to and the areas are covered, I'm not overly precious about where those areas sit. With regard to staff, we do report into the DBS service in the UK because I think we're duty bound to do so as part of our safeguarding structures.
So if a whistleblower comes forward with a health and safety matter, which we've talked about, and that, you know, you're not a prescribed body for health and safety.
No.
You're only prescribed for safeguarding. So how would you deal with that, or if it was a public safety matter?
Do you want me to pick?
By all means.
Whilst we're not a prescribed body for that, my staff are able to report any of those elements to any section of the department, and once again we would have to look at that and consider, do we need to bring in external view here, which has to be handled very carefully when you're keeping it anonymous. But if there's a health and safety issue brought to light, then it needs to be almost separated from the whistleblowing and anonymity element and picked up and dealt with. It can't be left to sit. Equally with the safeguarding that we were talking about before, you could end up with a whistleblowing process that needs to be run here and anonymised, but a safeguarding issue that has to be picked up and dealt with the appropriate body, who may be our safeguarding lead, but it may be elsewhere. It's a bit difficult when we're talking hypothetically and all of these things, but hopefully I'm being clear.
Okay.
Do you feel there's a clear understanding with staff employees about that definition of what is a whistleblowing issue and what is a grievance or a fairness at work? Do you feel that that's clearly defined and that there's a clear understanding of how those two separate issues sit?
With every member of staff, I couldn't say that, no. I think with a lot of these policies, they're complex. I think when you look at grievance and fairness at work and whistleblowing, we're talking about employment legislation. It's a very complex area. And I think what you'll find is most people, when they feel they are in that position, will reach out for advice. That may be to their union. That may be into an officer in the department to seek advice. It may be into HR. And I would urge them to do so, because the understanding of those policies is key. Equally, if a member of staff brings something to us through a complaints procedure or as a grievance, and it's not the right route, we will advise them on the best way to manage that.
So
I think the new whistleblowing policy has a really good workflow
It is clearer.
and checklist as well, which does help clarify that situation for some cases.
Okay. With regards to you talked about you'd make sure it went external or independent, and that if there is an independent report carried out or an independent investigation carried out, and there is a resultant report from that, I've just asked the previous CEO with regards to this, would you expect that report to be available to the individual raising the concern? Would you be open and transparent about that investigation process and that report? And if you've had any of them, would you see it prior to it being finalised, and can you make changes to it?
I wouldn't expect.
If it's independent?
I wouldn't expect to make changes to it. No, it's an independent report. If I make changes to it, it's not independent anymore. Would we share the report? It would depend on the report, and it would depend on the incident, because it may contain personal information or data on other individuals, and we would have to consider what redaction for release looked like, rather than just a blanket, yes, we would release. You would always hope to be as open and transparent as you could possibly be, but in an organisation, well, I was going to say this size, but in any organisation, there is a duty of care to everybody that is concerned here. So in the release of a report that may be highlighting other individuals, you have to be very careful.
Okay.
Yeah, I was just going to ask, when individuals do raise concerns, do you keep them informed about actions taken or outcomes reached? Is that fed back to the person?
My role, yeah.
And I guess since you raise actions, there, Mrs. Corlett, out of some of the historic cases, we have had actions. Absolutely, we've had actions, and we've put plans in place, and we've delivered those plans, and they've delivered good outcomes.
And the individual that raised the concern in the first
would
place
be aware.
Are made aware of what?
The recommendations would have been,
Obviously, whistleblowing policy is no detriment, no negative action towards any individual. How do you ensure that happens as Chief Officer? And if there is an external investigation, are you involved in the terms of reference, or if it comes into your whistleblowing officer, can you then go and create and do that completely separate from the management and leadership of the department? So you think it's serious enough to raise? I think you said you go to OHR. At what point, who's the decision maker of whether that goes to an independent investigation?
I think again it depends on the content of what the complaint is and who's impacted and affected by it, and to what level person data and things are involved. I know there's various other whistleblowing officers out there, especially maybe if it wasn't a safeguarding issue, if it was something else, then that, you know, advice can be sought from one of the other special areas, or probably have it more detailed as their responsibility. So whilst I haven't had a case, and this is all hypothetical, I do know there's a lot of advice and guidance out there depending on what the case or situation is. Would I feel I'd needed to come to my chief officer to make the decision? No.
Okay. And with regards to obviously the schools process, because that's the main bulk of your customers, if you like, that's the main people and group that you're looking after. Do schools deal with their whistleblowing themselves, or do they have, what's the flow process within the department for whistleblowing to a school direct?
All whistleblowing comes to one point. We don't have multiple points in the department for whistleblowing. So you can report to a line manager, as the policy clearly states, but it comes to one point.
Okay, and then obviously data controller comes into it because of schools being separate data controllers, and if somebody puts, if somebody is in the whistleblowing process and they put a DSAR in, to get data and information, are you confident that that's always adhered to within the, I think it's 20 days, is it still 20 days? You are confident with that?
Yeah.
Yeah.
I'm quite confident with that, and my background is data protection, and I'd be quite happy that we turn the information around and we do the protection when the protection is needed.
Okay.
In your submission, you state that you do not routinely use non-disclosure agreements in whistleblowing cases. It doesn't say you don't. So can you describe circumstances in which you will use an NDA and have done in recent years, and how many have you used?
I don't think we use the terminology NDA in our submission. It's not terminology I would recognise. NDA to me means something completely different. But we would use conciliatory settlement agreements, where essentially it's a legally binding contract that establishes a mutual terms by which employment may end. We use them where they are appropriate.
Have any employees or former employees, though, expressed concern that a confidentiality clause makes them feel restricted or silenced in any way? And if so, how would the department respond? And obviously any agreement doesn't protract from or take away from the whistleblowing process anyway.
Absolutely, and our agreements explicitly state that. So I would be surprised if nobody's ever come to say they feel that way. That doesn't mean they don't. I would be surprised if they do, because the final paragraph of our statement clearly says this in no way interacts into your ability to whistleblow.
Is that recently been put into statements, or has it always been part of it that you're aware of?
Put me on the spot now. Okay. As far as I'm aware, that's always been there. I would have to go and verify that, so I stand corrected if I'm incorrect there, but as far as I'm aware, that's always been there. And
obviously, because you're aware of conciliatory agreements that have been put in place, you'll be aware of the MERS process. Has the department ever used a mediation process?
Through MERS? Yes.
No, but internally within the department to try and mediate with the employee to, possibly make job changes or anything like that. You would always do that.
I think you would always seek to intervene at a lower level, and some cases you can deal with very early, and some cases escalate through the process. But you would always start by trying to do this without escalating to the top.
You've answered the question.
Oh, sorry.
I was going to ask there is actually where do you think this fits best, mediation? And you would say it's at that early stage.
Absolutely.
To prevent anything escalating that doesn't need to.
Correct, and I think Mrs. Scullett, that talks to culture, that talks to relationships, that talks to that ability to encourage people to come and tell us what the problems are. We're not deaf and we're not blind, and we don't want to not hear these things. I think a good, strong organisation learns from its staff bringing to light areas that can be improved. Otherwise, you're really not seeing those things.
We're obviously working on this committee to try and improve the situation, make it as best as it can be. How do we get to a stage where the employer, the biggest on the island, welcomes whistleblowing and in fact actually goes as far as championing whistleblowers.
How do we get to a stage? I'm not sure I could speak on behalf of the Isle of Man government.
Well, from your department then.
From my department, that is, I stepped into this role in September 2020. Wow, it's a long time ago. And from the very start, we've talked about people, relationships, culture. That's what you have to do. You have to treat people appropriately, you have to treat people fairly, and you have to value and recognise people. Out of that, you build relationships with people, and out of that, you develop the culture of your organisation. The reality is, it takes time. It doesn't happen overnight, unfortunately. Culture can be broken almost overnight, but it takes a long time to build. And I think we have to accept that the solution to a lot of this is developing exactly the culture that you highlight there, Mr. Glover, and it will take time for us to get there.
Because it's well documented that some of the most successful companies have evolved from correcting errors or correcting things that have been raised to them because they have welcomed and championed whistleblowing.
Yes, I agree 100%. I have absolutely no issues here. I welcome people bringing forward complaints. It doesn't have to be through whistleblowing. We have multiple channels. I welcome people raising concerns with us. It is how we learn.
Can you share any examples where you have learned from people raising things and improve things?
That would require me to speak of cases I'm not willing to speak about. There are examples, absolutely, but it's not something I can talk about here.
A number of witnesses, and obviously we've discussed this with most of the departments that have been in front of us with regards to trying to find a way of encouraging people to whistleblow and possibly have an independent process at that very outset, so there cannot be any confusion between whether it's whistleblowing or employment, so the decision's made. So, because a lot of people that come forward say that they start off whistleblowing and then they're getting diverted into employment. Do you think that would be beneficial? Because the expertise might not always sit as that whistleblowing comes in.
I can certainly see some benefit to what you're saying. I could see some complexity as well when you think of some of the roles that are within my organisation. I'm not speaking about wider government. There can be real specialism, there can be real technicality and difficulties with the understanding of some of those roles. I wouldn't say no, but I think it would need to be defined really clearly. It would need to be very, very well understood, and to ensure that it aligns well with the policy. I can see what you're saying, to try and remove. I don't think there's an awful lot of discrepancy there, but they are complex policies, so I can understand that sometimes people may be confused where the entry point is.
And I think that's it. We're all trying to get to a point where hopefully there will still always be whistleblowers, but there'll be no detriment to the individuals, and we shouldn't see employment tribunals going ahead if we're keeping it good. There has been comment with regards to our policy is very internalised, and it gives opportunity for no improvement, but for all detriment to an individual. How do you feel that internalised process works? So you go immediately to OHR. What process could be in place to make sure that the confidence and trust of the individual, that there'll be no detriment if you're already going straight to their employer, who might be involved in a later on in conciliatory agreements?
I understand the point you're making. There's a bit of a chicken and egg. This is just in my head, so I could be wrong, but we're trying to define and build a system that assumes the culture of the organisation is wrong. I would like to think the culture of my organisation is not wrong. It can always improve and develop. But if our focus is on getting the culture right, then we don't need to worry quite so much about those gateways and that front section. And the danger is that by focusing one way, we remove the bit or the focus from the bit that I think is a wider solution to this, is that a world where you don't need to whistleblow. You just come and knock on my door, you just write to me and tell me, and I'm going to pick it up and I'm going to deal with it, which if people do outside of any process will write and highlight issues, and absolutely we will pick those issues up and we will deal with them. The concept of detriment I find a very odd concept, because I don't understand why you would behave in such a way. Everybody has a right to raise concerns. They should be heard and they should be dealt with.
But the protection comes under the Employment Act,
It
doesn't
does,
it?
absolutely, I
and,
accept
and
that.
that's there, and that's
I
why
accept
there's
that.
prescribed persons lists. Sorry, John.
I think it's difficult, isn't it? Because we've got to remember we're dealing with human beings, and there's
We
always
are.
clashes of personality.
Yes.
That it doesn't matter what the culture is, that they are always going to arise. And how do we deal with that? And do you think some level of independence in the process would give the individual who's expressing concerns some confidence that the process is fair and that it's not being impacted by
Personalities.
relationships within their working sphere?
As I say, I can see the value of what's being suggested. It's a bit difficult without seeing how it's structured and how it works to say whether that would bring benefit or a further lack of clarity.
That's what I'm asking. Is that point worth considering?
I would think it's worth considering and worth designing what it may look like, yes.
Thank you.
No, just picking up on some of the discussion, and I'm very interested in the parallels between whistleblowing and safeguarding. And this discussion has triggered some memories of mine. Probably for, you'll know better than me, 20 or 30 years there has been a very successful campaign of awareness raising. We used to call it child protection, and then we call it safeguarding because it's not just children. And you know, in every part of life where you're dealing with children, whether it's at work or in the voluntary sector or whatever it is, everybody knows that there's going to be safeguarding procedures, there's going to be courses, there's going to be this encouragement of disclosure. And everybody has to be trained of what to do if they come across a disclosure. And I think it doesn't matter what I think, but I have observed that has become very widely known and understood. So my question is, turning to the issue of detriment, have you ever come across any situation where anybody has been subjected to detriment or has even believed themselves to be subject to detriment as a result of raising a safeguarding concern?
I'm not aware, no. I would suggest in the instances I'm aware of, the exact opposite. It's, as I said earlier on, it's almost an expectation. That is part of your professional duty, is to raise those concerns.
So why is whistleblowing different?
I don't know. I couldn't answer that question. I can see the parallel that you're drawing. No, I couldn't at this moment in time surmise, but I'm likely to go away and think about it now that you've raised it.
Can I follow on from that then with regards to third-party providers to either the department or to schools? What agreements are in place for those individuals around whistleblowing or safeguarding? Or anybody going into our educational settings, no matter which setting it is, are they party to having to comply with whistleblowing policies and safeguarding, because that's what you are a prescribed person for?
They are, yes.
They are. That's contractual to them. Okay. With regards to that. Anything else? Anything else?
If you were us, and you were to put one recommendation forward to Tynwald, what would it be?
Oh, wow, Mr. Glover. Can I come back on that? I mean, genuinely, I will... That's not something I feel I would just want to knee-jerk here, but I would happily come back to the committee with a view that says, actually, I've given that some consideration, because I think it warrants consideration. And I will come back to you when I've given it some time.
Thank you.
Can I just touch back on, because obviously there's lots of inquiries always happen on the island, and there's serious case reviews and things like that. how do you learn? And obviously the COVID inquiry raised some concerns around. How does the department ensure, I'm not saying you'll implement all recommendations, but if there's recommendations, do you ensure that those recommendations also reach any of your third-party sectors and everybody in the organisation, or are they learning in the centre and not devolved down?
No, they would have to be learned and then disseminated. Now, whether they disseminate out into third-party organisations that are working with us would depend on what the learning was and what the change was. But, you know, if we had a contractual position with a third-party organisation and we made some change, we would have to inform them. So you would have to loop that back. But it's not just learning that sits in the centre, no. You know, we meet regularly with senior leaders across the organisation. It's back to that cascade model to say, everybody needs to be aware. Please take this back into your part of the organisation and disseminate that through whatever method you disseminate to wider staff.
And as Chief Officer, sitting on the Chief Officers group, is whistleblowing a topic that comes up, or does it only come up when you see an employment tribunal?
Comes up in what respect?
Is it something that's openly discussed from, because it's the culture that obviously all chief officers will be very interested in. Obviously we've got a committee running. Is it a topic that comes up? And with regards to the recent implementation of the changed policy, does that go through the chief officers group first before it's implemented by the PSC?
We would be cited on such, and the conversations.
Do you approve or just cited? Do you approve it
I would
or
have to
cite?
check how that came through in that particular instance. I couldn't off the top of my head tell you what that process was. But I think the conversation at Chief Officer Group is much wider. It's much more around culture. It's about organisation. It's about how do we enable people to speak up. We are all conscious of the need to enable this to happen, to enable our organisations to improve. But equally, we are all conscious that it unfortunately won't happen overnight, if only.
So what would you say to all your employees today if they wanted to speak up?
Speak up. Speak up. But it's speak up to who you feel comfortable with, isn't it? It's not approach a whistleblowing officer, because there's something about a relationship here that if I want to get into a difficult conversation of something that I have witnessed and I feel should be raised, I'm highly unlikely to go and speak. I may, that's unfair. I'm unlikely to go and speak to somebody I don't know. I'm going to want to speak to somebody that I have a relationship with and I can trust. What we need to ensure is that those people, those line managers, know what their process for raising that further is, so that it does, if it has to reach the whistleblowing officer or if it has to reach me. But what I would say is, speak up.
Okay. Anything else?
No.
Anything else? Okay. Thank you for your attendance here this morning. We will suspend this sitting.
Lovely, thank you.
Thank you. Good afternoon. Welcome to this public meeting of the Select Committee of Tynwald on Whistleblowing Policy Implementation. I'm Julie Edge, MHK, and I chair this committee. With me today are Tim Glover, MHK, and Call at MHK, and our clerk. Please can we ensure that any mobile phones are on silent or switched off so that we do not have any interruptions. And for the purposes of Hansard, I will be ensuring that only one person is speaking at any one time. So thank you for attending today. Would you mind just introducing for your record what capacity you are appearing in here today?
Yeah, so I'm Scott Wilson. I'm a current employee of the Department of Health and Social Care. And if I may just introduce myself as to why I'm here, if that's possible.
Sorry, say that again.
As to why I'm here. I've got a little statement here. So it gives you a bit of background about civil servants. And
Can
stuff.
I just read something out prior to that? So,
Yeah, certainly.
so obviously before we begin going into any statements of that, I just want to explain how the hearing will proceed. So Dr. Wilson, can I check that you received an email sent to you by the clerk of the committee on the 30th of January explaining the committee's plans for this public session?
I did.
Okay. So the committee's agreed to hear from you in public because you have said that the substance of your evidence relates to the operation of the whistleblowing policy and governance rather than to sensitive personal detail. We think that it might be useful for you to be able to discuss your own experience. However, as that would involve other individuals, it's appropriate to hear that in private. While we're sitting in public, therefore, we only wish to hear about your recommendations for policy and governance of whistleblowing or any other matters of public policy. At this stage, you may not say anything about your individual experience and your case. We can do that later in private if you wish. Mm-hmm. So are you content to go ahead on that basis?
Yes.
Okay, so could you continue to introduce yourself?
Yeah. So I'm a civil servant and a whistleblower. I raise concerns in the public interest about safeguarding and regulatory failures affecting children and vulnerable people, using the routes required by law and government policy. I am not here to argue any ongoing employment matter. I am here to assist the committee in understanding how whistleblowing policy operates in practice and what happens when disclosures are delayed, independence is absent and protection is withdrawn. This is the reality. In the public session, I will focus on systematic and governance failures. I'm willing to provide detailed case-specific evidence in private session where appropriate. I hope my evidence helps the committee strengthen protections and restore confidence in whistleblowing arrangements. I am conscious, however, of the possible repercussions of today's evidence as I am in receipt of a cease and desist email sent to myself.
Okay, thank you. So with regards to the whistleblowing legislation and policy, after the last whistleblowing select committee, there was recommendations and it was suggested by that committee that it should be rewritten to encourage reporting of concerns and make it clear. Would you say that that has happened? And obviously since that committee there's been either 2 or 3 renditions of that policy.
Yes, and in fact, the one that's now been, I believe, that was first issued in October 25, there are grave concerns, and I've listed some of those with that policy itself, if I'm able to. Yep, thank you. So I wish to draw the committee's attention to several concerns regarding the Isle of Man government's revised whistleblowing policy issued in October 25. Having reviewed the document alongside the earlier draft circulated this year and the previous 22 policy, a number of changes appear to weaken practical protections for whistleblowers, while increasing procedural complexity and the potential for retaliation. For example, the reporting process. The reporting process introduces a requirement for disclosures to be made through a departmental whistleblowing officer, who must then notify the Office of Human Resources. This represents a significant change from the 22 policy, where employers could report directly to several recipients, including their line manager, chief executive, the Audit Advisory Division, the Public Services Commission, or a prescribed person under the Employment Act. The revised policy introduces an additional intermediary within the department before the concern reaches any central oversight body. This may discourage reporting and increase the risk of internal retaliation. It also creates a structural problem where the departmental whistleblowing officer themselves could be the subject of that disclosure. The policy also states that, that details of the reporting arrangements will only be finalised later, meaning the operational framework remains incomplete even though the policy has already been issued. Given the sensitivity of whistleblowing disclosures, the absence of a finally defined reporting framework is concerning. With regards to data handling, the revised policy also introduces central oversight arrangements requiring departments to submit progress reports to the information to the Office of Human Resources. This represents a clear departure from the 22 policy, which relied on decentralised handling of cases within departments. The creation of a central register of whistleblowing disclosures raises significant data protection and confidentiality concerns. The policy does not clearly explain what information will be shared with the Office of Human Resources, how it will be securely transmitted and stored, and who will have access to that information, or what safeguards will prevent identification of whistleblowers in small departments or specialist teams. Although anonymisation is mentioned within the policy, this provides limited reassurance in smaller teams where only a number of individuals could realistically be connected to a particular issue. Without clearer safeguards, the centralisation of this information risks increasing rather than reducing the potential for retaliation of breaches of confidentiality. Governance conflicts. A further concern arises from the governance structure surrounding the Office of Human Resources. During a previous sit-in to this committee, the Public Services Commission indicated that reports provided to the Office of Human Resources do not contain the identity of the whistleblower. While that may be a stated intention, the practical governance arrangements raise serious questions about whether anonymity can realistically be maintained. The head of the Office of Human Resources sits in the advisory role on the Public Services Commission. This creates an inherent conflict where the same organisation responsible for human resources policy is also positioned within the oversight structure for whistleblowing arrangements. During the same committee session, members of the Public Services Commission also stated that the Commission itself had no employees directly allocated to it and relies on advice and support from other parts of government. This raises a further question. If the Commission has no staff of its own, then who drafted the whistleblowing policy? And on behalf of that Commission? If that work was undertaken by OHR, then the policy cannot reasonably be described as independent. It would instead represent a policy written by the same organisation that is responsible for oversight and administration of whistleblowing cases. A further inconsistency arises from the Commission's own evidence to this committee. It was stated that the Employment Act takes precedence over the whistleblowing policy. If that is the case, it raises the obvious question as to why the policy does not clearly follow the legislative framework set out in the Employment Act. If the legislation ultimately governs whistleblowing protections, the policy should align closely with that framework, rather than introducing additional processes and reporting structures which may create confusion or weaken protections in practice. Last bit. In my own case, these governance concerns are particularly relevant. An official from the Office of Human Resources was tasked with drafting the terms of reference.
Okay. Can we talk about that in the private?
Yep, of course, certainly.
Yes.
So basically, in conclusion, there is confusion around the reporting routes. So the 22 policy clearly set out reporting routes including the Public Services Commission, the Audit Advisory Division and prescribed person under the Public Interest Disclosure Framework. The 2025 policy introduces two parallel systems. One route involves internal reporting through departmental whistleblowing officers with mandatory onward reporting to OHR. The second route involves reporting to prescribed persons under the Public Interest Disclosure Framework. This creates uncertainty for employers about which route must be used in order to obtain protection under the Employment Act as amended by the Employment Amendment Act 23. There is therefore a real risk that an individual can report a concern in good faith but unknowingly do so through a route that fails to secure statutory protection. That's it. Yep, I do.
Okay. Is that?
Yes.
That's the end of your statement, yeah. Okay. Is there anything else with regards to the policy and obviously the procedure that you'd wish to raise safely in this public session?
Yeah, what I did do after, I followed this throughout all the people that have attended, and okay, I can't talk about employment matters, but currently being suspended, I've got lots of time on my hands to look at things that have been said. So I've done a bit of research into the claims by the PSC that this is a leading piece of policy across the UK, and there was specific references to Scotland's whistleblowing, and this was claimed to have been better than that. So what I've done is a comparison, which does sort of bring into disrepute slightly our whistleblowing policy, if I may, because it finds the holes and loops that are in there. Am I permitted to do that?
That's fine.
So, excuse me for sniffing, by the way. So thank you. When whistleblowing frameworks are compared internationally, the key distinction is rarely the wording of the policy itself, but whether the system includes an independent mechanism capable of reviewing how disclosures are classified, investigated and concluded. I've reviewed the Isle of Man whistleblowing policy issued in January, I've put 26 because that was the last time it was updated, and compared it with the Scottish Civil Service Framework for raising concerns, which was referred to by the PSC. The Isle of Man government has suggested that its policy is stronger than those in the United Kingdom. When the two systems are compared, the difference appears to lie less in the wording of the policies and more in the structure of the systems that support them. Both systems contain procedures for reporting concerns, but the Scottish framework incorporates additional safeguards through independent oversight mechanisms. So the Scottish framework that was referred to is that whistleblowing is directly linked to the Civil Service Code. That code sets out core principles of integrity, honesty, objectivity and impartiality, which civil servants are required to uphold. Where a civil servant believes those standards may have been breached, they are expected to raise a concern. If that matter cannot be resolved internally, the individual can escalate the concern to the Civil Service Commission. The Civil Service Commission operates independently of government departments. It has the authority to investigate alleged breaches of the codes and to examine how departments have handled whistleblowing concerns. This means that the department concerned is not the final authority on the classification or investigation of that disclosure. These independent oversight mechanisms is widely regarded as a key safeguard in model whistleblowing frameworks. The Isle of Man whistleblowing policy describes how concerns should be raised and handled within government departments. Typically, disclosure are expected to be raised through internal channels such as line managers, more senior managers or departmental whistleblowing contacts. Investigations are usually conducted within the same organisation framework as the department concerned or commissioned by that organisation. While the policy references confidentiality and protection from detriment, it does not appear to provide a clear pathway through which concerns about departmental governance can be reviewed by an independent body equivalent to the Civil Service Commission. As a result, the organisation responsible for the alleged wrongdoing often remains responsible for determining how the disclosure is classified, investigated and concluded. These bring together some structural considerations. Two features of the Isle of Man framework may warrant particular consideration. First, disclosures generally enter the department management structure at an early stage. International research on whistleblowing systems suggests that the greatest risk to whistleblowers occur shortly after a disclosure is made, particularly where the concern relates to a senior staff or organisational culture. Second, the policy distinguishes between whistleblowing and matters such as grievances, dignity at work complaints or employment disputes. While that distinction is common in many policies, the organisation itself often determines how that concern will be categorised. In some circumstances, that may result in concerns being redirected into employment or grievance processes rather than being treated as protected disclosures. Additional observations, and obviously there's an increased retaliatory risk. So a further consideration in whistleblowing systems internationally is the potential risk of retaliation where disclosures are routed through internal management structures at an early stage. Where concerns are raised within the same organisational hierarchy that may be the subject of the disclosure, there is a possibility that the matter may quickly become entwined with workplace processes such as disciplinary or employment procedures. In some systems, that risk is mitigated through independent escalation routes that allow the concern to be assessed outside the organisation before such processes arise. And then we look at the independent scrutiny of the investigations. Another structural difference between the two systems relates to the oversight of investigations. The Isle of Man policy places emphasis on internal reporting procedures and departmental investigation processes. However, it does not appear to provide a clearly defined independent mechanism through which the adequacy of an investigation can be reviewed. In Scotland, if an individual believes that their disclosure has been handled inappropriately, that matter can be examined by the Civil Service Commission. The independent scrutiny helps ensure that the investigation of a disclosure is not solely controlled by the organisation concerned. So the structural differences, within the two systems. When the two frameworks are compared, the principal difference lies in the presence or absence of independent oversight. The Scottish system recognises that whistleblowing sometimes requires scrutiny outside the organisation being criticised. It therefore incorporates the escalation routes to independent bodies such as the PSC. The Isle of Man policy relies primarily on internal organisational governance processes, where the same organisation retains responsibility for classifying the disclosure, conducting the investigation and determining the outcome. The effectiveness of the system depends heavily on internal institutional integrity rather than structural safeguards. So I've got my conclusion, which is the Isle of Man policy contains many of the procedural elements expected in whistleblowing frameworks. However, to claim that it is one of the leading ones in the UK and amongst other jurisdictions cannot be claimed. The Scottish framework incorporates an additional layer of independent oversight, which allows concerns about breaches of the Civil Service Code or any other government department or at arm's length organisations to be reviewed outside the organisation concerned. That structural difference is significant when assessing the level of protection and independence available to individuals raising concerns. For that reason, if the Isle of Man framework is considered stronger than those operating in Scotland and the wider United Kingdom, it would be helpful to understand what independent mechanisms exist within the Isle of Man system that performs the adequate role of the civil service in Scotland in reviewing how protected disclosures are classified, investigated and concluded.
Okay, thank you.
Thank you.
Any questions?
No.
In your opinion, then, what role should the PSC be playing here?
When I first joined the civil service 16 years ago, there was almost like a complete independence of the PSC. You knew they were there and they were feared. I think now it appears to me personally that the PSC isn't independent at all. It's just another arm's length office of the civil service. So I think they truly do need to be independent of OHR, whether they sit there as the secretary to give advice on policies, procedures or whatever it is they do. There is no independence whatsoever. So really it's just like in view of my personal situation, it just looks like another couple of people sitting in an office to give the appearance that it's independent when it's clearly not.
So when you were employed, it was by the PSC, not the Civil Service Commission, because the Isle of Man did have the Civil Service Commission, which is the one you're talking about, I think. So we were originally employed under the Civil Service Commission, which had quite a strong legislative framework.
Yes, okay. Indeed, yeah.
Okay.
Is this a bit like a separation that we've seen in planning policy, where there's one group of people doing the policy and then there's a different department which does the operations? And you're saying that OHR is operational, and there should be a greater separation between them as operational people from those that are setting the policies.
That's correct. That's the view I believe, that it should to offer that bit of independence and scrutiny and oversight. I think at the moment it seems to be very much a very closed network with no independence whatsoever.
And are you saying that the PSC today is less independent than the Civil Service Commission was in days gone by?
Without a doubt.
And is that something you can explain? Is it because of the way the legislation was rewritten in 2015, or is it because of the way the people doing the jobs are doing them at the moment?
I think across the board it's the way that it's structured. So the changes have diluted this independence. It's almost like a network of and it may sound unprofessional, but friends, you just put friends in places that just agree with everything you say. I don't think there is that separation in any way, shape or form. And I am aware that that is not the case, which I would bring up in the private session, because notification of my whistleblowing and suspension got out into the public.
Right.
That's that point. Just with regards to the legislation and the current legislation that's in place, do you feel the government bodies understand that? Because when you're talking about independence and that, do you think the legislation is correct the way it is and could be utilised with a Scottish system, which is the Civil Service Commission? There were significant changes to the Civil Service Commission Act, to the PSC, and in particular with the reporting frameworks that were in the Civil Service Commission Act. I have to declare I did work under that act, so I'm very familiar as to how it worked.
Well, with the legislation as is applied from the UK under the Employment Act and with the Amending Act in addition to that, there's clear loopholes in it, which I believe now, listening and following this for the duration of since it's been on, and that is that potentially or allegedly certain departments may be taking advantage of that loophole, and that loophole is clearly, and it's in there because my role is policy and legislation. I can read and understand policy and legislation, and that is that it's a simple loophole that we push everybody down an employment route, absolutely everybody, and then that weakens the protections that the whistleblower has because it's now an employment matter. And I picked up on that originally on the 10th of October, I believe, maybe the 9th of October in Tynwald, because I know that the Chief Minister mentioned employment matters. The next day, Mr Ashford talking about there was one case and stuff like that. Again, employment matters. I listened to the solicitor that was here. Employment matters. They are not. However, there's another case that's recently been in the Supreme Court that's ruled you cannot separate whistleblowing and employment matters. You can't separate them if there's an element of whistleblowing and an employment matter. That's the loophole, and I believe that's the loophole that the departments, government, whoever it is taking full advantage of.
Thank you.
Obviously, thank you for your submission and the details there. And it largely focused on independence and bringing independence into the whole process. Aside from that, where else do we go to create a culture where, as most best employers do, encourage whistleblowing and champion it? How do we get to that stage in your view?
Well, I think the first thing is to accept that whistleblowing has sometimes, as in my case, was just a concern to start with, which could have been dealt with so easily. Now, I was then told to whistleblow, so I whistleblew. And it just, I think in order to do it, I think what we need to do, we actually need to just be open, honest and transparent and follow the Nolan principles that we're all supposed to follow. And if we're sort of told as civil servants, these are our duties, these are our responsibilities, well, why is it then we're then put up of a brick wall when we move up the chain? So I think to change it and to bring it in, you need to change it from the top down. The culture needs to change. It's all right having these words saying, oh, we're going to do this, we're going to treat people differently after the ransom case, we're going to do this. Well, do it. Don't just talk about it, do it. Let's see the tangible outcomes. Let's see whistleblowers sort of, I'm not saying embraced to an extent where everybody can just come and whistleblow about things that don't require whistleblowing, but why is it that we're still isolating these people, whistleblowers? Why is it we're treating them unfairly? Why don't we put that time into resolving what the whistleblowing issue is before it becomes this big blown out of control sort of thing?
So before, obviously we'll move into private shortly, but with regards to training and whistleblowing, did you have the training? Are you confident that throughout government that training's appropriate and it's adhered to, that it's mandatory?
Okay, so in the idea of being open, honest and transparent, those lead courses are not taken seriously. When you have to do them to get the tick box so the department can say, yes, we've all done it, it's simply get on the screen and see how quick you can click to the end to say you've done it. It's not taken seriously, and they're so basic that it just misses the point.
And how could that be changed to get that culture change?
Again, I don't want to, sort of advocate unnecessary costs for government, but if I'm personally saying there's a cultural issue with it, how can those very same people be training the rest of the staff on how to do things? Again, it's not the training. You can have all the training in the world, but it's how it's put into practice and how it's supported.
And it's not a big part of that, how that training is monitored and evaluated.
Most definitely. Yeah,
on
yeah.
the trainee side, the feedback from, you've taken that course, what do you now know about it? How would you respond to something? Is that not absolutely critical in this? Because if a department doesn't know the impact of the training...
No, it doesn't.
Particularly if it's mandatory. If it's important enough to be mandatory, surely it's important enough to be monitored and evaluated.
Exactly that. But then we can call any training mandatory if we want to give that illusion that we really care. And from my experience, we still don't care. We're still shut down the whistleblower, isolate them, and then move off.
I think we've had 3 instances now where we've slipped into your own experience. It's not supposed to be discussed in public.
Okay, I apologise for that and withdraw that. But similarly, I believe it just needs to be taken more seriously, and we need to look at the quality of the training.
Okay. Yeah, anything else? No.
No, go to private.
Okay. You're happy to go into private session now. Thank you. We'll now sit and